Welcome to Family History Mysteries, a podcast that tells the stories uncovered through family history research, the unexpected stories of everyday people. I'm an avid family historian who's been compiling my family tree for over 15 years, with now nearly 20,000 people collectively recorded in my trees. Episode 6, 4 Marriages. The person that I'm going to be talking about today is Elizabeth Ascot. She was my great-great-great aunt. This person piqued my interest as she was not only married 4 times, but most of her husbands died a very short time after their marriage to her. So I was thinking, is this something sinister or was it just bad luck? So I'll start by giving you a little bit of background of Elizabeth. Elizabeth Ascot was born on the 22nd of September 1825 in Halberton, Devon, England. Her parents were Thomas Ascot and Elizabeth Upton. Thomas was a wheelwright. That's a person who makes or repairs carriage wheels. Elizabeth was the third child of 12, and 4 of the children, including Elizabeth, emigrated to Australia. Elizabeth married Henry Ferris in Tiverton, Devon, England in April 1845 when she was 19. Their oldest child, Charles, was born 1 month before they married. They had 2 more children before emigrating to Australia in 1851. They arrived in Port Phillip Bay, now known as Melbourne, Victoria, as free settlers on the 2nd of May 1851 on the ship the James T. Ford. Henry's occupation on the shipping records was a wheelwright, like Elizabeth's father. In fact, Henry was listed as living next door to the Ascots in 1841, so could have quite likely worked with Elizabeth's father or simply met her as the next door neighbour. Elizabeth's brothers, George and Thomas Ascot, both joined them on the voyage out to Australia, and they were both blacksmiths. They resided in Brunswick, Victoria when they first arrived. Henry opened up a business with Elizabeth's brother George, and that was also in Brunswick. An advertisement for the business stated that they were machine makers situated on the New Sydney Road near the Retreat Inn. In 1857, Henry sold his business interests and homes. By this time, he had done very well for himself. In 6 years, he'd acquired 4 lots of land, 3 homes, and a wheelwright blacksmithing business in Chapel Street, Prahran, near the Royal Albert Hotel. They moved to Newham, Victoria, which is near Kyneton, where Elizabeth's sister Jane and her husband decided to settle as well, and they are my great-great-great-grandparents. Henry purchased land at Newham and became a farmer. On the 1st of February 1862, only 5 years after their move to Newham, Henry died aged only 36. There must not have been suspicious circumstances surrounding his death, as no coroner's report was found for Henry. They had 7 children by this stage, with the youngest, William, only 3 years old, and Elizabeth was newly pregnant with their 8th child, Susan. Henry made his will on the 27th of January 1862, only days before his death. And the will states, I, Henry Ferris of Newham, near Woodend in the colony of Victoria, farmer, do declare this to be my last will and testament. I give, devise and bequeath all my real and personal estate and effects unto my wife Elizabeth Ferris and Thomas Purvis of Newham, a farmer, and Joseph Pacey of Kyneton in the said colony, merchant. They are appointed as executors and administrators in trust of my personal estate to collect and call in all such portions thereof as shall consist of money, and to call in and convert into money by sale thereof of all portions, and shall thereout pay all of my just debts, funeral and testamentary expenses, and to invest the residue of the said monies at interest upon government or real sureties in Victoria, and pay and apply the annual income of the said trust monies in the same manner as hereinafter directed to the rents and profits of my real estate. I direct my said trustees to let or lease my real estate for such a term or terms of years to such persons or person at such rents or rents, and generally upon such conditions and in such manner as they may think fit, provided that the term or terms of years created by any such lease or leases shall not be before 7 years, and I direct my said trustees to apply the proceeds and interest of my said personal estate and the rents and profits of my said real estate in and towards the maintenance and support of my said wife and my children, and the education and advancement of my said children in such manner, in such proportion, and at such times as to my said trustees may seem expedient and proper, and upon any youngest surviving child attaining 21 years of age, or upon the decease of my last surviving child, if there shall be then living any issue of a deceased child or children. I direct my said trustees to sell my said real estate either by public auction or private contract, with power to insert any special or other stipulations in any contract or conditions of sale as otherwise as they may think proper, and to pay and divide the monies arising from such sale or sales of my real estate, and also the entirety of any said residue personal estate, and all interest and accumulations, respectively, between and equally amongst my said wife and my said children, as shall be then surviving, or the issue of any of my children who shall be then deceased, such issue of a deceased child, to take on the loco parentis. And if all my said children shall die without attaining 21 years of age, or without leaving lawful issue, then I give, devise, and bequeath all my said estates, real and personal, to my said wife, if she shall be the only living person absolutely, and to be at her sole disposal. And I appoint my said wife executrix, and the said Thomas Purvis and Joseph Pacey executors of this, and I appoint my said wife during her life and after she deceases, the said Thomas Purvis and Joseph Pacey guardians and guardians of the persons and estates of my children, and I hereby declare, as often as any of the trustees hereby appointed under their power shall die or be discharged or decline or become incapable to act as trustees, hereby then reposed, and it shall be lawful for my said wife during her life and after her decease for the then trustees or trustee from that time to continue to act. And I declare that the trustees for the time being shall be chargeable for any such monies only as they respectively shall actually receive, although they or any of them may give or sign any receipt for the sake of conformity, and shall not be untowards to others. And also it shall be lawful for them out of the monies which shall come to their respective hands by virtue of the trust aforesaid to reimburse themselves respectfully, and also to allow other respective co-trustees all costs and expenses which they may pay or sustain in executing the will. And part of the documents in the will show Elizabeth Ferris's statement as part of her role as one of the trustees of the estate. In the Supreme Court in the Colony of Victoria, in its ecclesiastical jurisdiction in the will of Henry Ferris, late of the parish of Newham in the county of Burke in the Colony of Victoria, deceased. I, Elizabeth Ferris, of the parish of Newham in the county of Burke and Colony of Victoria, widow, make oath and say that I believe the annexed paper writing to be the last will of Henry Ferris, that I will pay all his debts and legacies so far as the property left by him, and as the law binds me to do so, that I will exhibit a full and true inventory of all his property together thereof into the registry of the Honourable Court when lawfully required, and that I believe that his property does not exceed the value of £590, and that is signed by his wife Elizabeth Ferris. 5 years after her husband Henry's death, Elizabeth married William Henry Greenwood at the age of 41 on the 23rd of March 1867 in Kyneton, Victoria. William was 10 years younger than Elizabeth. He was born in Woolwich, Kent, in England, and records for William are scant. He isn't mentioned in many newspaper articles, and I can't find his emigration records. There is one article I found in the Kyneton Guardian on the 1st of May 1872, so a little shy of 5 years into their marriage, and it is titled Conjugal Troubles. In the article, Elizabeth claimed that William used threatening language towards her and that she desired protection from her husband, who lived at Coburg near Kyneton. It then stated that she had altered her mind and settled the matter out of court. William Greenwood died on the 13th of January 1874 at the age of only 39 years old, and it was only a little over 7 years in total of marriage. There is no record of a will for William, but Elizabeth was featured on a forfeiture of a land licence in June 1881, and this was a land licence that she was seeking at Alumna and Yelka, which is in northern Victoria. By the 20th of June 1882, so a year later, this lease was approved for the same selection, which was 320 acres, and under the name E. Greenwood. 5 months later, Elizabeth married James Finesse on the 10th of November 1882 at the Registrar's Office in Flemington, Melbourne. She was 57 and James was 52. James was born in Norfolk, England, and arrived in Melbourne on the 20th of May 1874. James had been approved on a land lease at Alumna West in April 1882, 2 months prior to Elizabeth's successful land lease and 5 months before their marriage. In May 1883, Susan, the youngest child of the union between Elizabeth and Henry Ferris, appointed an attorney to ensure the wishes of her father were administered, as she was the youngest child and had just turned 21. Remember, there were 3 executors appointed to oversee the estate of Henry Ferris: Elizabeth, James Purvis, and Joseph Peasy. They had the responsibility of releasing the trust funds from monies earned from leasing the Newnham property and the sale of this property once Susan reached 21 years old, and it was then to be divided between his children and his wife. By the time Susan had petitioned, James Purvis had died, so it left 2 executors to release the funds. Susan explained that she appointed an attorney as she was not getting a response from her mother or Mr. Peasy. Her attorney sent a letter on her behalf and still no reply from either of them. The attorney and Susan were aware that the farm had been sold and the money was in the bank under the control of the executors. The attorney claimed that the delay in the distribution of funds was due to the executors not taking any action. On the 29th of October 1883, I found a court case related to the will. Ferris versus Finesse. Mr. Justice Molesworth delivered judgment yesterday in the undefended administration suit of Ferris versus Finesse. The proceeding was brought by John Ferris to have trust carried out under the will of the late Henry Ferris, his father, who died in August 1882. The proceedings were in connection with the distribution of funds in the bank taken to represent the residuary estate. The will directed the equal distribution of the estate between the widow and 8 children. One of the testator's daughters married and has since died. The distribution proposed was that the estate should be divided into 9 shares, one being given to the family of the testator's deceased daughter and the others to his wife and children. The deceased's widow, who had since married Mr. Finesse, was the only person who had not consented to the distribution. She objected, as she did not think her grandchildren were entitled to any share, and His Honour considered her reasons for objecting foolish and insufficient. The plaintiff entitled to the ordinary administration decree, whom I shall make, but I do not think that I should specifically perform to the proposed plan, it assumes that the other property, personal and real, properly expended, being neither more nor less than debts and outgoings, which the bill does not allege, and of which there is no evidence, or of the widow's agreeance on this. There are many deductions made from the money in the bank of the property of which, or of the widow's concerning to which, I have no evidence, and as far as I can judge, she is taking a very mischievous course in her opposition to all the others. This shall increase costs for which she might be held personally responsible, and to secure which her share in the bank would be liable to be attached. The usual administrative decree was made, with the qualification that accounts were to be taken only where some of the parties required them. If they are not otherwise enforced from her, I think her distributive share of the testator's assets, about £200, may be attached to meet the usual administration account qualified, by saying such accounts only to be taken as any party may desire. Further directions as to costs and leave to apply where reserved. So basically what Judge Molesworth is saying is that he believes that Elizabeth is acting in a deceiving manner as the trustee, and he's saying that he's basically ruling that she's not going to be getting any of the share, and the share that is put aside is going to be covering the administrative court costs in place of her receiving it. 5 months later, on the 28th of February 1884, again we see another court case. Arguments were heard by Mr. Justice Molesworth in equity yesterday in the suit of Ferris versus Finesse, which came before the court on further directions. Mr. A. Beckett appeared for the plaintiffs, Mr. Top for the defendant, Elizabeth Finesse, and Mr. Wellgall for the defendant, Peasy. The plaintiffs were the sons of Henry Ferris, late of Newham, farmer, deceased, and the defendants were Elizabeth Finesse, widow and executrix of the deceased, and Joseph Peasy, executor. The testator by his will directed that when the youngest child came of age, the estate should be divided between the widow and children equally, each taking a ninth share, and the offspring of any deceased child should take its parents' share. One child died, leaving issue, and it was on account of this that the whole difficulty arose, as the defendant, Elizabeth Finesse, alleged that she had a copy of the will, according to which the offspring of a deceased child had no interest. His Honour had previously decided in the plaintiff a favour, and the matter now came before the court for further directions as to costs, the plaintiff claiming that Elizabeth Finesse should pay his costs up to a degree. Mr. Top, however, urged that Mrs. Finesse had acted in the best of intentions, though no doubt her judgment was wrong, and under these circumstances it would be hard upon her to be compelled to pay all the costs. His Honour reserved his judgment. So basically what has happened here is that the judge has asked for them to go away and work out the exact costs, administration costs associated with the will, and then he's asked for this to come back so he could make a decision. Unfortunately, I can't find anywhere in the newspaper articles the result of that court case, so we're not sure whether Elizabeth in the end did get her share or whether it went to the 8 other children. Just a point though, read the will out and you would have noticed that it quite clearly stated by Henry that if he had a child that had been deceased in that time before the youngest child was 21 years old, that it could then go to their children if they did have children. So Elizabeth was claiming that the complete opposite of that. At this point, I'm probably not putting Elizabeth in a very great light. So I think it's time for me just to give you a little bit of perspective of how women were seen in society at this time. In the early years of the Port Phillip colony, women were treated as second-class citizens. Women couldn't vote, they weren't allowed to do the same work as men, and they had no distribution in government. There was an expectation that women would marry and tend to the home as wives and mothers. And we need to remember too that women had no right to property ownership, and if you were married, you didn't have control over your wages. So married women had fewer rights than single women in the laws in those days. There was a law of coverture, and it basically meant that once you got married, your legal identity was merged with your husband's. You lost control over things like owning property, earning wages, and being able to sue or be sued. By the mid-1800s, women were still denied rights, basic rights that we would consider to be basic today. Attempts at improving the rights of women were started by the Victorian Women's Suffrage Society in 1884 with minor success, and the right to own property was given to married women in 1884 with the Married Women's Property Act. And this is important to know because I've just been reading out the court records, and that's February 1884. What happened with the Married Women's Property Act was it changed the law of coverture, so women could now own, sell, and buy property in their own name. They could keep their own wages, they could enter into contracts and sue or be sued in court. So James Finesse, that's Elizabeth's third husband, he died of liver cancer on the 18th of January 1885, and he updated his will on the 16th of June 1884. Elizabeth was placed as administrator of that will on the 29th of January 1885. 10 days after her husband died, she was placed as administrator of James's will. Elizabeth had only been married to James for a little over 2 years. Interestingly, on the 26th of August 1878, when his original will was made, he left everything to Elizabeth, and at that time was known as Elizabeth Greenwood. This was 3.5 years after William died, and it was 4.5 years before Elizabeth and James married. So even in his original will, she was going to be the person that was going to benefit. James also made Henry and William Ferris, Elizabeth's sons, his testators at that time. However, when probate was to be issued after James's death, it was found that neither will had been submitted to the office of the Registrar General, and it needed to be advertised to see if anyone other than Elizabeth was going to lay claim to the will. On the 19th of February 1885, so around a month after she was placed as administrator, the estate in its entirety was granted to Elizabeth. In this estate, she received 319 acres of land and 300 sheep. It stated that there was no house suitable on the property and that Elizabeth and James had lived on her property that was separate. And this was the property that she purchased after William's death. So she now effectively has a 320 acre property and a 319 acre property. A little over a year after James died, she married Alexander Coghill in Melbourne on the 12th of April 1886. He was 39 and she was 60. Alexander was Scottish. He was born at Wick, Caithness, Scotland on the 9th of June 1846. He resided in Alumna in 1882. His mother lived there, as well as his brother David, and another brother James lived in Yarrawonga, Victoria, not far away. The land records at Beerai, Victoria, which is very close to Alumna, in 1889 show that Elizabeth held 320 acres of land in the Beerai township under the name E. Greenwood. She'd married twice since William Greenwood's death, but she was still under her married name with that property. It also shows that D. Coghill, who I assume is Alexander's brother David, held adjoining land. So he held a total of 319 acres right next door to Elizabeth. It also shows that Beerai has 2 streets. It still has 2 streets, a Ferris Street and a Furness Street. Is it possible that they are named after Elizabeth Ferris and James Finesse? Alexander was a farmer and was found unconscious in a paddock on his farm on the 4th of January 1907. The coroner's report found that it was likely he fell off his horse. And this is just an excerpt from an article, local paper, referring to Alex's death. Mr. Coghill had many friends, and his death will be greatly regretted. He was studious of habits, a great reader, and in his capacity for 10 years as chief carpenter on board the P&O and other lines of boats, he had visited most ports of the civilised world. He was 58 years of age and had resided in this district for over 25 years. The funeral, which was very largely attended, took place on Sunday, the remains being interred in the Numurkah Cemetery, which is the nearest larger town. The will is very interesting and it comes up with a few questions. He left his will to First of all, his servant Julia Brown, who had been his housekeeper for 12 years. He left his implements and stock to her. He left the rest of his will to Edward Reed and Thomas Stephen Maloney, his friends, and they were also the trustees of the will. Elizabeth, his wife, and Julia, the housekeeper, were given the proceeds of the rents and profits of the property for the remainder of Elizabeth's life. He stated that once Elizabeth died, all personal effects and real estate are to be given to Julia Brown absolutely. If Julia Brown died prior to Elizabeth, Julia's daughter Mary would benefit. The will was written on the 9th of May, 1903. 9 months after William's death, a newspaper article was found on the 8th of October, 1907. A Farmer's Will, His Widow's Remarkable Story. In the practice court on Friday, Mr. Justice Hodges was asked on behalf of Edward Reed and Thomas S. Mahoney, executors of the will of Alexander Coghill, farmer of Alupna, to direct that the estate be administered under the direction of the court. The matter came before the court on an origination summons, and the parties interested under the will, Mrs. Elizabeth Coghill, widow of the testator, and Mrs. Julia Brown and her daughter Mary Brown, were represented by counsel. Alexander Coghill died on the 4th of January, and he executed his will on the 23rd of May, 1903. Under this, he directed that the income from the estate should be divided between his widow and Mrs. Brown. Mrs. Coghill has made a claim for the whole estate, asserting that 319 acres of land at Alupna were transferred by her to her husband on the direct understanding that it was to be worked for the benefit of herself and husband, and it should pass to the survivor. The widow also claimed the stock and goods and chattels of testator, and she had also submitted a claim against the estate amounting to £554 for money lent. In Elizabeth's statement, she claimed she owned the land, and going back through her other husband's wills, it seems the land ended up in Vanessa's name, which she was awarded when James died, and then she sold it to Alexander. Keep in mind that I obtained the land records of 1889 for Biri and Alupna, and it doesn't say that an Alexander Coghill owned that 319 acres of land at Alupna. It said a D. Coghill had. So when Elizabeth has stated that her husband took over the ownership of that land, clearly is stating that a D. Coghill had, and certainly not William. The will directed that on the death of Mrs. Coghill, the whole estate of testator should go to Mrs. Brown and her daughter. When the parties were married in 1882, the testator was 38 years of age, and Mrs. Coghill, who was over 60 years of age and had been twice previously married, well, we know that it was 3 times married, possibly with William Greenwood's application for an annulment. He was successful with that, so she wasn't acknowledging that marriage at all. But she ended up with William Greenwood's land, remember, so we know that on the 1889 land records that she has that 320 acres in her name. Counsel on behalf of Mrs. Coghill said that when Mrs. Brown was brought into the house as a domestic, she looked over the whole management of affairs, and soon after all communication between Mrs. Coghill and her friends was stopped, and Mrs. Coghill was practically kept a prisoner in her own home. Testator treated her cruelly and forced her to draw money out of the bank by beating her. His Honour directed the trial before a judge of the Supreme Courts of Issues as to whether Mrs. Coghill was entitled to the land, goods, and chattels of testator, or they were part of a testator's estate. In this action, Mrs. Coghill was to be plaintiff and Mrs. Brown and her daughter defendants. The executors were directed not to appear in the action until judgment was given. Unfortunately, we don't know what the court outcome was between Elizabeth and Julia Brown, except that Elizabeth ran up £1,000 in court costs fighting this will. Elizabeth died at the Melbourne Benevolent Asylum on the 28th of July 1908, aged 82 years. The Benevolent Asylum housed the aged infirm, disabled, or destitute of all creeds and nations. And because we know that she had run up £1,000 in legal bills trying to fight that will, I am under the assumption that she was destitute and unfortunately found herself penniless in the asylum at the end of her life. I also don't think it would have helped that she had decided to be the only one, when contesting the will for her first husband Henry, to say that her grandchildren were not deserving of a portion of the will. So I also suspect that her children wouldn't have been more than happy to take her in and care for her in her later years, as would have been the customary option for families, particularly remember in those days that there were no formalised aged care facilities for older people to go to. And most times, a lady particularly would be cared for in her son's home or in her daughter's home. But because of her actions years earlier, I assumed that there wouldn't be too many willing family members to have taken her into their homes. The land, which she still held in her name, the 320 acres, was advertised for sale after her death in 1908 by her son, Henry Ferris, and it was sold in 1909, and it did end up going back to the Coghill family. How did Elizabeth Ascot's children fare, particularly after the death of their father, when most of them were quite young? Remember that the oldest child was only 16 when Henry died, and we suspect her marriage to William Greenwood wasn't without problems. By the time Elizabeth married William, she still had 4 children under the age of 16, and Susan, the youngest, was only 5. The oldest Charles married Harriet Matilda Ida Body at St Paul's in Kyneton on the 29th of October 1865 when he was 20. They lived at Sutton Grange, Inglewood and Ferntree Gully in Victoria before moving to Queensland in 1886. They had 11 children. He died on the 24th of September 1931 in Brisbane, Queensland, and he's buried at Lutwyche Cemetery. Mary Ferris married Jonathan Boxall in 1863 in Victoria. She was 16 years old. They lived in the Newham-Kyneton area. They had 12 children. Only 4 survived childhood. Jonathan was a farmer, and Mary died on the 16th of October 1923 at Kyneton. Elizabeth, the third child, married Joseph Tedge in 1866 in Victoria when she was 18. They had 7 children. 4 of them survived childhood. They lived in Bendigo, Melbourne, and the Macedon area. Joseph was a farmer. Elizabeth died on the 1st of October 1881 in Lancefield, Victoria, aged only 33. A coroner's report outlined how Elizabeth's body was found and listed the death as unknown. However, evidence in the coroner's report leans more to suicide, as there was a note found in her belongings at her sister Mary's house at Cobor in Victoria. This is the child referred to in the will documents as the deceased child, and this was the basis of the contentious issue in the will of Henry Ferris, and whether the next generation were able to receive the proceeds of Elizabeth's share of the will. So, considering that her mother Elizabeth tried to deny that of her daughter's children, it's also probably extra cruel, the fact that her daughter seemed to have suicided, left her children behind, and her mother still didn't feel that they were worthy of a share. And in addition, we would assume that Elizabeth was named as the namesake of her mother Elizabeth. The 4th child, John, married Elizabeth Quirk at age 26 in 1878 in Victoria. He was a farmer and they lived in the Kyneton area. They had 8 children. John died on the 2nd of September 1919 in Melton, Victoria, aged 67. Henry married Sarah Jane Moore. This was his first cousin, as Sarah's mother, Jane, was Elizabeth's sister. They married at Paran in Victoria on the 13th of August 1877 when he was 22. They lived in the Kyneton area not long after their marriage, and he worked as a wheelwright. He became a hotel keeper at Moira, which is a small township near Rushworth, and he owned the National Hotel, and he was 46 at the time. He was also running a farm. He died aged 55 at Mora, Victoria in 1910. They had 10 children and 6 survived childhood. I don't have a lot of information on Thomas. Thomas worked as a wheelwright with his brother Henry in Kyneton as a young man. However, he has been recorded through other family trees as dying on August 1876, aged 19. However, I'm unable to find a formal death certificate for Thomas to verify that. William married Janet Isabella Boxall on the 10th of June 1880 in Talbot, Victoria, when he was 21. They lived at Kyneton, Talbot, Longwarry and Druin in Victoria. He was a farmer. William died on the 23rd of August 1946 in Dandenong, Victoria, aged 87. They had 10 children and 9 of them survived infancy. The youngest, Susan, married John William Jones in Newham, Victoria in 1879 when she was 17. They lived at Campbellfield, Lancefield, Numurkah, Druin and Colac. They then moved to Tasmania at around 1910, where John had been born and was raised, and they are recorded in the census living at Yolla, Tasmania in 1914, which is in the northwest of Tasmania near Devonport. They had 6 children. It seems, though, that only 2 survived childhood. Susan died at Burnie, Tasmania on the 27th of December 1953 and is buried at the Wivenhoe General Cemetery. I mentioned earlier in the story that Elizabeth emigrated to Australia with 2 brothers, and a sister, Jane, also emigrated a couple of years after them. So I thought I would let you know how they fared after they emigrated to Australia. The first was the oldest, George. So George Ascot, as you would recall, was in business with Elizabeth's first husband, Henry Ferris, and he married Jane Tyrrell on the 8th of February 1854 at Pentridge, Coburg, Victoria. He purchased land at Chewton in Victoria in 1857 and then moved to Newham near Kyneton in 1874 and purchased land there. And he died on the 5th of October 1874 in Newham, aged 52. Jane Ascot met Bean Moore on her voyage out to Australia in 1853. They married on the 1st of March 1854. George Ascot was a witness in their marriage, and they married at the same church at Pentridge, Coburg, Victoria, as George did. They lived in Brunswick until 1859 when they moved to Black Hill near Kyneton. Bean was a woodcutter and a farmer who later owned property at Cobourg near Kyneton. Jane died in Kyneton on the 17th of July 1909, aged 77. And Thomas Ascot married Emma Levy in 1853. He lived in Brunswick until 1859 when they moved to Campbell Creek near Castlemaine in Victoria. He went to court in May 1871 in Castlemaine when he was 40, but was not tried as he was found to be of unsound mind. In 1876, he was living in Echuca, separate from his family it seems, and was charged with robbing a person of £6 after drinking at Dunley's Hotel. So now we're starting to get a bit of a picture, and it's seeming that Thomas had quite a drinking problem. In February 1877, he was charged with wife desertion. Emma claimed that he drank, and then when he drank, he became physically violent, and she left him and returned to Melbourne. Emma refused to return to Thomas, and the case was dismissed. The reason why the case was dismissed is that when you put in a police gazette a warrant for a charge, the expectation is 2 things. Either you are expecting your husband returns, or you are expecting maintenance to occur, which would mean ongoing communication. Once Emma realised that, I think she had decided that she didn't want anything to do with him, and it was easier for her just to dismiss the case. By August 1882, Thomas was mentioned in a perjury court case in Echuca. He wasn't found guilty. In March 1883, he was charged with stealing 2 bars of iron and was sentenced to 6 months in Sandhurst jail. Sandhurst was later Bendigo. By 1886, he was living in Cow Swamp, northwest of Echuca. In 1892, he commenced a job contracting as a labourer, blacksmithing on irrigation works. He died in March 1893 at Cow Swamp, aged 62. In the coroner's report, the local policeman said he generally drank his wage, although workmates said he was a fairly steady man. He was found in his tent by his co-workers, and his cause of death officially was lung disease. Australia was a land of opportunity in the 1850s. You could emigrate here and make a real success of yourself, or alternatively, you could go down the wrong path like Thomas Ascot. So after everything you've heard, do you think that Elizabeth was a victim of a lack of rights of women, or was she motivated by greed? I'll let you be the judge. Please go on my Facebook page, Family History Mysteries. You'll see photos of some of the people I've talked about today. If you have a mystery or an interesting story that you would like shared on my podcast, please contact me through my Facebook page. And if you've started your tree and need a bit of assistance in filling it out and adding some stories in like I have, please get in contact.